Hello, ladies and gentlemen. Today I would like to start my little series on European labor and employment law for dummies. Let's start with employment law. I think for non-Europeans there are three striking differences. The first one is the phenomenal high protection for employees, especially US employment lawyers can't believe it. Yes, we do not have employment at will. We have notice periods, and in almost all member states, you need to have a reason before you can dismiss a person. And the reason must be engraved in the law. It's not just non-discriminatory. So in many countries, the hurdle is quite high to dismiss somebody. Furthermore, the employment contracts are very common. The European law even says that the main terms and conditions need to be written down and given to or handed over to the employee. And employees enjoy various rights. They have minimum wage according to the member state. They typically have a continued salary in case of illness. They have mandatory social benefits such as retirement benefits or illness benefits or care benefits. They also have maximum working time, and they enjoy paid vacation days plus public holidays. I know, I'm coming from the country where you have typically 30 vacation days plus 10 to 12 public holidays. You really wonder when the Germans work. We also have normally non-competes, meaning we don't have the California rule that they are not allowed, but they come with a price, meaning that they are scrutinized by courts significantly. They need to be proportionally in time, in regional scope, in terms of the task. And in many countries, you need to pay a compensation for the time being. And last but not least, we have, as you probably know, severe data privacy rights that come into play more and more. That was the first level, I would say. The second key feature is that we have at least two-level representation of employees as a collective. One is the level of unions and one is the level of works councils. I will talk about the labor law specifically in another video next time. And thirdly, I think the third key feature is our different litigation system across the continent. First, litigation is quick in Europe. A recent survey showed that the first instance is done in 3 to 6 months. It's mostly dealing about unfair dismissal, less so with discrimination and the like. It's less costly compared to the US. That includes attorney fees, but also court fees. There's a smaller industry around it because we don't have witnesses normally. We don't have experts normally. We do not have class actions. We don't have jury trials, and we do not have any punitive damages. So the incentive to go to court is probably lower than in the US. That concludes my remarks. I thank you for listening. If you have any further questions, please do not hesitate to contact me. Thank you very much.